The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon, members and industry friends. Thank you very much for joining us on this afternoon's webinar. My name's Joanne and I'm Head of Marketing and Communications at AFTA. And we have put together a fantastic webinar program so far. So it's wonderful to see that over 300 of our members are on this afternoon's webinar. I've got on the line with me AFTA CEO Jason Westbury and Head of Finance and Strategy Courtney Duddleston.
Hi.
Now, before I hand over, just a little bit of housekeeping. Every single webinar is recorded and is placed on the AFTA website. An easy way to find it is to use the promotional tiles on the AFTA homepage, which will be a quick link through to the webinar recordings. You are all in listen-only mode, but we do invite questions. So please use the toolbar to write any questions that you have, and we'll address these as best we can at the end of the webinar. Hold your questions to the end if you can, because no doubt many of those that you have, we will address them throughout this webinar. But of course, if there's something specific that we haven't covered, we are more than happy to address that. So I'm now going to pass over to Jason to take us through the JobKeeper payment.
Thanks, Joe. Hi, everybody. Thanks for jumping on and joining. This obviously is another very big announcement that the federal government has made. And like all these things that are flying around, it's difficult to get on top of it and unpack it. This one is a specifically complex one. But hopefully at the end of this, we will have been able to give you enough information that you can take it away and apply it to your own circumstance. Later on in this webinar, Courtney will go through some specific examples that we've sort of made up, if you like, and hopefully that might apply to you. Some may not specifically apply to you, and others might apply to you more. So just bear with us as we go through those few case studies that we've effectively manufactured, and then of course we will definitely have time at the end, and I also might say that we may not know the answer to all of your questions, because this is really just the onion's just starting to peel back, but if we don't know the answer, we know who to go and ask, and we'll then get either back to everyone or back to the individual if it's something very specific. So JobKeeper. Look, I've said in the media already that I honestly believe this is really a nation-saving strategy. It is something that I don't think anybody would have ever thought a coalition government would do. It is really quite incredible in our history that an Australian government has been able to come to terms of this nature with the opposition and the unions, all in hand in glove with an outcome. I can also say to you that there will be a special sitting of Parliament next Wednesday that will pass all of the necessary awkward pieces of ancillary legislation to make this happen. And there is pre-agreement that it's going to happen. There might be some posturing and some questioning and some carry on for those that are at home with nothing to do, for some entertainment. If you watch Question Time next Wednesday, you might find that entertaining. But the assurances are well and truly given that this is going to happen. So, and the reason why that's important is that everyone has to be able to start the process of coordinating themselves. And we don't want to have a scenario where we all get ourselves organised and then they do another press conference and go, sorry about that. We didn't mean it. So there's no question this is happening, and people should feel confident to progress as soon as they're in a position to, if they decide to implement these processes into their business, with the full confidence that all the necessary laws will pass. In terms of what we're going to try and talk about today, as I say, we're going to sort of talk about more about what is it, who's eligible. I would have to suggest, I haven't seen a list of the 60 odd people, but I would say everybody's eligible in the travel industry, and we'll talk about why that is the case in a minute. We'll talk about how do the employees get it and how do the employers get it. So sort of the two pieces of the puzzle, and then obviously at the end we'll get to questions. Hopefully all of your questions will be answered as we go through. So in terms of the job, so I'm just gonna, whoops. Sorry, Joe, am I still there?
Yes, you're here, and we've got the JobKeeper Payment summary slide up.
Sorry, I've just had a small technical hiccup here. My apologies. Don't despair. NBN is holding true. So look, the JobKeeper Payment is aimed at really cementing the relationship between employer and employees. If you like, really what this is the government has looked to find a way to not put everybody on social security. And if you think about it, you know, even a week ago, as people, particularly in the travel industry, were standing down people and coming to arrangements to terminate and coming to arrangements to put people off and terminate employment and go all through the various versions of what that looks like, we were detaching from our employees, and the queues at the Centrelink offices were becoming kilometres long. The idea behind this is to try and take all those people that would otherwise be in that queue off the queue and put them back into the hands of the employer. That's one of the fundamental foundations of this concept. Now, we could debate for hours whether you like or don't like that. That's what it is. They have apportioned $130 billion for it. Now, that number is made up on the basis that they effectively had envisaged that if unemployment had got until a level of 15% of our workforce and everybody had gone on social security, they would have been paying that bill. So they'd already done the workings out of how much it's going to cost to put everybody on the Australian government's payroll. So that's what this is putting everybody they can put on the Australian government's payroll onto the Australian government's payroll, except they're looking to employers to effectively create a connection with their employee and utilising the existing services of that payroll to effectively pay the money. The package fundamentally is a flat $1,500 per fortnight per eligible employee. We'll come back to that in a second, and paid to the employee by the employer. So through the normal payroll system, however you would normally work to pay your people, that is how this would work. And it is factored on the value is factored on fortnight. Now, if you pay weekly, if you pay monthly, if you have a different payment cycle, you are able to continue to do it as you would have done it, knowing that you've got the $1,500 gross coming in to supplement your payroll. Now, in terms of the amount, it is a gross amount. So if you only give the people $1,500 a fortnight, you will have to take out the tax that's applicable to a pay of that level, which is around about $40,000 a year annualized. And on the Australian tax system that's loaded into your payroll systems, the amount of tax when you process that in payroll would take the tax out, and you would then remit that tax through your normal measures of PAYG tax, which would still go to your total and your tally for the various PAYG returns that have been announced in previous packages. And I know it's a jigsaw puzzle. I know how jigsaw puzzling this looks, but it is part of the jigsaw puzzle. It all interlinks and interweaves to that PAYG jigsaw puzzle. So even though you will have taken it out of the person's hand and given them the amount, that amount will go to your tally, so that ultimately when you reach the $100,000 PAYG threshold, as in what you've paid, you'll get it back. In terms of the concept of who's eligible, it's for employees that were an employee of yours, be it full-time, part-time, or casual. Not that there's a lot of casuals in the travel industry, but I don't know what everybody's business looks like, as of the 1st of March, and that they had been in your employ for 12 months prior to that. That makes them eligible. They also have to be an Australian citizen, or there's a few other subclasses, particularly for New Zealanders, where I think it's a 444, visa 444 from memory. That's not on the slide, so that's a memory thing. But if you've got any backpackers, working holiday maker people, non-Australians, people on 457s, 482s, none of those people are eligible. It is only for Australians. Okay, and I've already got people feeding into me how that's not fair, that doesn't help, that's no good. I've got employers that have got members that have got people that are employed in all sorts of various obscure but remote locations. Think about the hospitality industry with chefs who are specialists, who are here from another country, specialist chefs on a 482 or a 457, they don't get it either. It is just for Australians, the theory being that every government in the world is meant to be looking after their own people. So that's the facts of it. As I've said, in terms of the application, it's from the 1st of March 2020. So there is a retrospective aspect to this. In terms of the employees and the employers, so how you become an eligible employer is that in our case, you would have to have a turnover of under $1 billion, and you have to demonstrate that you've had a decrease of 30%. Pretty much, there would not be a travel agent in Australia that doesn't comply. So as far as I'm concerned, everybody complies, and if you're in a position that you don't comply with that, call us and we'll work out what you are thinking. For the really big end of town, and I don't know if there's any of those people on the call, but just so that we don't preclude anybody, this is really the first measure that the government's brought out through the whole COVID-19 recovery, where the entire economy is eligible. Now, a big business over $1 billion has to demonstrate that they've had a reduction in sales of 50% for a year-on-year comparative. Again, no brainer, because if anyone's got any sales, I'd still reckon they'll be well under 50%. Again, if that's you and you're unsure, so that you make contact with us directly. And also self-employed individuals who effectively have themselves as an employee will also, after meeting the turnover tests, be eligible. So you'd have to go hard to not be an eligible employer in the travel space. I just need to, sorry, I'm just moving something. There we go. On the employees side of things, as I said a little just before, there is the category. It's relatively easy to work it out. If the person's been employed with you on the 1st of March and they've been with you for the last 12 months or more, and that they're an Australian citizen, or as I said, holder of the, there it is, thank you, Courtney, of the special class of visas, the subclasses are there. There's not many. It certainly helps New Zealanders here on this subclass 444, and there's plenty of those in the Australian industry. Then the employee is eligible. Now, if you have already stood them down or offered them a redundancy or terminated them or whatever you may have done, it is more than likely that they will be eligible. It's the idea of it is to take people off getting entitlement from Centrelink. That's the fundamental piece about employees being eligible. So that slide is a good one to flow through. And if when you work through and you apply, your employee's name Sam, and you look at what Sam's situation is and you apply those few dot points to Sam's status, if you get to the end and think, right, Sam meets all those criteria, stop asking whether they're eligible, they're eligible. As with most things in government, this has not been given the ironclad oversight and horrendous amount of contemplation that things normally get in government, and there is a lot of wiggle. I took part in a teleconference with the Minister for Tourism this week, where he said they know, they being the government, that there will be what they've called leakage, meaning that because they haven't wrapped this up in a whole heap of normal level of regulatory craziness, that there will be people that perhaps maybe weren't who they thought or shouldn't be, or they're on the edges. But the general, because the fundamental theory here and the general theory here is that they want the employee to maintain some connection to the employer. So that's the eligibility piece. In terms of the further pieces around that, in terms of if you're a PTY, if you're a sole trader, if you're a partnership, beneficiaries of trusts, all of those things have been thought about, and slowly but surely the ATO is releasing more and more and more detail, and as soon as we get it, we'll provide it. If you haven't yet registered on the ATO website, I think, Courtney, you've got some slides at the moment about that specific piece, but you will find that if you're connected to the ATO, it costs you nothing to do it. You don't need to feel like you're doing the wrong thing by lodging your intent. You will get the information as it flows. So will we, and we'll continue to try and unpack that information and get that out in a travel kind of lens as best we can. Courtney, is there anything that you think you wanted to just add to this slide before I pass over?
No, I think you've done a great job there, Jason. So happy to continue. And like Jason said, we've got some examples just to really try and put this into context for our members.
Okay, over to you.
Okay, thank you. Okay, well, thanks, Jason. And thank you to everyone who is joining us today on the webinar. In terms of how employers receive the JobKeeper payment, it's a relatively easy process, which we've broken down into steps to really try and simplify for you. So as Jason mentioned, first off, you must elect to participate in the scheme by registering your interest online now through the ATO website, which has been listed here. Employers will subsequently need to apply for the JobKeeper payment through an online application, which is not yet available. So AFTA's already opted in for the scheme, and from memory, you will need to provide your business name, ABN, and contact details, including your name, email, and mobile number. Step 2, employers will need to provide information to the ATO to demonstrate the necessary downturn in their businesses. For eligible employee details, the ATO will use single touch payroll to pre-populate the details. And as Jason mentioned earlier, for those businesses without employees, they will need to provide an ABN, nominate an individual to receive the payment and provide that individual's TSN and provide a declaration as to recent business activity. People who are self-employed will also need to provide a monthly update to the ATO to declare their continued eligibility for the payments. So the JobKeeper payment will be delivered through monthly arrears via existing systems at the ATO, and employers will be required to provide monthly updates to the ATO on the number of eligible employees employed by that business. And I expect that this will be an automatic thing done through single touch payroll. So the first payment will be reimbursed by the ATO from the first week in May, but it will be backdated until the 30th of March. And the payment is expected to continue for up to 6 months, running from 30 March to approximately 1st of October. So how does the JobKeeper payment affect the amount an employer must pay their employees who are employed as of 1st of March? There's 2 scenarios here. Where an employee currently earns under $1,500 per fortnight before tax, then put simply, they're about to get a pay rise, provided that they're an eligible worker. Employers legally need to pass all of the $1,500 JobKeeper payment to the employee, even where this is more than the employee currently earns. It will be up to the employer in this circumstance to decide if they want to pay superannuation on the additional wage earned by that employee because of JobKeeper. So for example, if the employee normally earns $1,000 per fortnight, you will still be required to pay superannuation on this amount, but it is up to the employer if superannuation will be paid on the additional $500 per fortnight that they are earning from this payment. If an employee ordinarily receives more than $1,500 before tax per fortnight in income, employers will now receive the $1,500 JobKeeper payment towards their salary, but will need to continue to top up this amount to their regular income amount. The employer will be required to continue to pay superannuation on the employee's regular wage or salary. So to put this into context, we've included an example of an employer with different types of employees on different wages. Let's say Adam owns a travel agency business with 2 employees. The business is still operating at this stage, but Adam expects that turnover will decline by more than 30% in the coming months. Adam's 2 employees include Anne, who is permanent full-time and on a salary of $3,000 per fortnight before tax, and Nick, who is permanent part-time on a salary of $1,000 per fortnight before tax. Both workers continue working for the business. So Adam is eligible to receive the JobKeeper payment for each employee, which would have the following benefits for his business and the employees. The business continues to pay Anne her full-time salary of $3,000 per fortnight before tax, and the business will then receive $1,500 per fortnight from the JobKeeper payment to subsidise the cost of Anne's salary. Adam will also continue paying superannuation on Anne's income. And secondly, the business continues to pay Nick his $1,000 per fortnight before tax salary and the additional $500 per fortnight before tax, totaling $1,500 per fortnight before tax. The business receives the $1,500 per fortnight before tax JobKeeper payment, which will then subsidise the cost of Nick's salary. The business continues to pay the superannuation guarantee on the $1,000 per fortnight of wages that Nick is earning. The business has the option of then choosing to pay superannuation on the additional $500 that is paid to Nick. So we've included a slide here with a question that we've had a lot coming in lately from members. So hopefully this might answer a few questions some of you might have. So let's say you are running a retail travel agency with a number of employees. Unfortunately, right now there is no work coming in, and for various reasons, your employees are unable to work from home. If you were to apply for the JobKeeper payment and then pass this on to your workers, are you essentially paying them to do nothing? Well, put bluntly, the answer is yes, you are. This is about getting people off the job seeker payment and allowing you to place your business essentially into hibernation mode. The JobKeeper payment will allow you to remain connected to your employees so that when the rebound does happen, you've maintained them on the books and there is no additional paperwork, training or costs involved. You will receive from the government the $1,500 per fortnight before tax for each eligible employee, which would then pass on in its entirety before tax to the employee through your payroll system. And Jason, is there anything that you would want to add before we continue?
Thanks, Courtney. Look, I think the difference between those 3 examples is really critical, because the first example, whereby the $3,000 worker is continued to be paid the $3,000, is entirely up to the business. Because the simple fact is, you would only do that if you've got something for them to do. If you don't have anything to do, that is that you've put your business into hibernation mode, which is certainly the case for retails. It may not be the case for corporate, but everybody's situation is different. The second slide, which is the question and answer version that Courtney has, would apply, and it's difficult because it may be that you want to keep one working with you because that's what you've got work for, to deal with cancellations and changes and communication with existing clients, because you can't do it yourself. So yes, you would have to pick your favorite and determine which one you want to do what with. In terms of the 1,500 sit at home and do nothing piece, again, it's up to you how you manage that with your people. From the feedback I'm getting amongst the majority of travel agency owners, the loyalty of people is demonstrating to me that nobody wants to sit at home and do nothing. But if you're not equipped, if your business is working on desktop computers and you don't have laptops and they don't have internet connection and you're not set up for it all, there's no expectation. You then have to have the additional burden of rushing out and trying to reorganize yourself to suddenly have to try and run your business from 5 different people's apartments in the front bedroom. So we're trying to give you a broad brush, multiple different versions of, from the questions we've already received, but there isn't really a fundamental directive here. This is each individual business's decision to do with as they wish, obviously complying with the general premise of the rule, which Courtney's attempted to try and lay out for you. Now, if through the question and answer at the end, you've got a couple of specific examples that you want to run, then by all means type them up and we'll do our best to answer them for everybody. Probably best not to name names, just so we don't know, we're not talking about anyone's specific business by name. But if you've got some examples that are more complex than what we've attempted to demonstrate, happy to take them either online or offline through the course of the webinar or afterwards. So I'll hand back to you, Courtney.
Okay, thanks, Jason. Okay, moving on. So in regards to employees that have already been stood down without pay, these employees and their employers are still eligible for the JobKeeper payment. Employees who have been stood down must be paid at a minimum the $1,500 JobKeeper payment per fortnight before tax. It will be up to the employer in this circumstance to decide if they want to pay superannuation on the JobKeeper payment to their employees. It's worth noting that a person receiving the JobKeeper payment cannot also receive the job seeker payment. And if they have been stood down after 1st of March and have since applied for income support, then they will need to notify Services Australia, or formerly Centrelink, to withdraw their job seeker. And I do want to address and answer a question that we have seen pop up from members lately, which is, can I direct my employee who's been stood down and subsequently receives JobKeeper from me to do work? Well, the answer to that is no, not while they've been stood down. A stand down, by its very definition, means that an employer's employees cannot be usefully employed by the employer because of a stoppage of work for which the employer cannot reasonably be held responsible. So unless an employer decides that they can usefully employ their employee and ends the stand down, employees cannot be directed by their employer to do work, even when they are receiving the JobKeeper payment. So I will run through an example here of an employer with employees who have been stood down, which might be a little bit relatable to some people here. So let's say Tim owns a travel agency business. Ordinarily, he employs 3 permanent part-time consultants, but with no more work, he can no longer operate as normal and has been forced to stand down his 3 employees without pay. Tim has determined that his turnover will decline by more than 30%, so his business is eligible to apply for the JobKeeper payment for each employee and must pass on this full amount per fortnight before tax to each of his consultants for up to 6 months. Tim will maintain the connection to his employee and be in a position to quickly resume his operations. Tim is required to advise his employees that he has nominated them as eligible employees to receive the payment. It is up to Tim whether he wants to pay superannuation on the additional income paid to the 3 employees because of the JobKeeper payment. And if Tim's employees had already started receiving or applied for income support payments like the job seeker payment, they will need to advise Services Australia, as employees cannot be in receipt of both payments. If some of Tim's employees have since gone out and gotten other jobs after he stood them down, they will still be eligible to receive the JobKeeper payment from Tim. However, they will not be eligible to also receive the JobKeeper payment from their new employer, as employees can only receive the JobKeeper payment from one employer. Now, in terms of dismissed employees, if an employer has dismissed an employee since 1 March, then they could now look to be re-engaged by the same eligible employer, and they'll be eligible to receive the $1,500 a fortnight JobKeeper payment. So this effectively means that employees who have been laid off since 1st of March 2020 can be put back onto the books. And I do want to put it to an example of just how this has already been put into practice, which is exactly what AFTA has done recently. So unfortunately, on Monday morning, 2 of our employees were made redundant. And by Tuesday morning, after this initiative was announced by the government, we had our heads around it, we had subsequently offered them their roles back with AFTA. Remember, a person receiving the JobKeeper payment cannot also receive the job seeker payment. So if they've been dismissed and they've started the process for applying for income support, they would need to withdraw this. Okay, so to put this into context for you, we've included an example, and bear with me as there is quite a lot of content, but hopefully this will make it easy to understand of how this would work in this instance. So let's say Ingrid runs a travel agency business. On 1st of March, she employed 1 full-time consultant, Scott, who was on a salary of $2,000 per fortnight, and she had 2 casual staff, Jennifer and Tammy, who earned $1,000 per fortnight. And the casual staff had all worked regularly for the travel agency for longer than 2 years. Unfortunately, Ingrid had to let Tammy go due to a reduction in her business. So with the announcement of the JobKeeper payment, Ingrid now considers that she may be able to afford to re-engage Tammy as a casual staff member again, as the JobKeeper payment means the following for her business. Ingrid will continue to pay Scott his full-time salary of $2,000 per fortnight before tax, but she receives $1,500 per fortnight from the JobKeeper payment to subsidise the cost of his salary, meaning she only needs to pay the remaining $500 per fortnight before tax towards Scott wages. Ingrid will then receive $1,500 per fortnight before tax to subsidise Jennifer's salary. As this is more than Jennifer's current $1,000 per fortnight salary, Jennifer will see an increase of $500 per fortnight before tax being paid, while Ingrid's receiving this JobKeeper payment. And Tammy can then be re-engaged by Ingrid, and Ingrid will then receive the $1,500 per fortnight before tax JobKeeper payment, which will subsidise Tammy's salary. As this is more than the $1,000 per fortnight salary that Tammy is offered to be re-engaged at, Tammy will also see an increase of $500 per fortnight before tax being paid, whilst Ingrid is receiving the JobKeeper payment. So that have been some really helpful resources that provide information around the JobKeeper payment, and I would encourage all attendees to visit the ATO website, the business.gov website, and the Treasury website to further familiarise your obligations around this initiative. So hopefully this has provided a little bit of clarity around the JobKeeper payment. We have no doubt that many of our members will be able to benefit from this initiative. And so before we move on to questions, I do want to highlight that employers should at all times be conscious of their particular legal obligations applicable under the Fair Work Act, their respective state and territory legislation and workers' compensation legislation, as well as enterprise agreements, awards, contracts, and policies. AFTA always advises that members seek their own advice before acting or relying on any of our content. So we can now run through some questions that you may have, and for this, I will hand you back over to Jason and Joe. Thanks, everyone.
Wonderful. Thanks so much, Courtney. Got a few questions here, so just bear with me as I read through them.
While you're doing that, Joe, I'll just say that one of the reasons why it's important for these things to be recorded and for the slides to go up is that even just sitting there listening to that myself, even my head's now spinning. So I'm sure everybody on the call will be feeling the same way. The good thing about this resource, and as soon as Joe's able to get it wrapped up and onto the site, it will become, some of those slides would be a really great checklist for you to sort of run through your own situation comparatively to the Ingrid and the various other names that are there, and insert your own thinking and use it as a bit of a tool and a template to run the ruler over your own individual situation. And so, you know, it will be available as soon as we can practically make it. And I would suggest that we'll also be running supplementary webinars about this particular package over the coming days.
That's a great point, Jason, because I can see a couple of questions in here are what we have covered off, but there is a lot of information, so it may have been missed. So I might just pull out some of those and we can readdress it. So the first one here is, can you please clarify the obligation of employers to pay superannuation on the $1,500?
Well, from my sitting of that is that if the person was employed and earned more than $1,500, you would be eligible to pay the super. Courtney?
That's correct. So if the employee was still working within your business and you were receiving the JobKeeper payment, if they earned under the $1,500 per fortnight before tax, you would only be eligible to pay superannuation on their normal salary and wage. You are not required to pay superannuation on the amount that is above and beyond that to the $1,500. However, if they were earning more than $1,500 before tax per fortnight, you would be required to pay superannuation on their normal salary and wage.
Great, thanks, Courtney. Thanks for clarifying. I read legislation, Jason. It hasn't been legislated yet. It still needs to go through the process of that.
Look, the general legislation that was passed in the emergency COVID-19 sitting last week has provided for an appropriate framework for the government to be absolutely convinced and confident that they've got the ability to appropriate the $130 billion allocation. So that piece has been passed because they effectively handed the Prime Minister a blank checkbook. Just to put it into real simple terms. But what needs to happen is there are some prevailing other pieces of legislation that to ensure that there is an appropriate level of understanding and, if you like, legislative protections within the industrial relations space, and more broadly the way in which employers and employees are to act, is the sort of subset pieces that I understand have to be passed on Wednesday of next week. But I believe they are really quite functional and quite procedural, rather than in any way a substantive that would mean that this would be blocked.
Great, thank you. Courtney, we were discussing this before the webinar started, and I've got a few questions here asking clarification around if you work for yourself, so you're a director of your own company with no employees, or you're a sole trader and you don't necessarily give yourself a wage, you just take owner's drawings. Can you just clarify around how they'll be eligible for that and how the ATO would know to pay those individuals?
Yeah, okay, great question, Jo. So if you're an employee, obviously the ATO will be going off the single touch payroll. At this stage, because the application process hasn't been opened, we're not completely aware of what sort of information they're going to require for sole traders, people that aren't employed. But it will be things like providing ABN, your name, as far as we're aware. Jason, I don't know if you've got any more on that at this stage.
No, I don't. That's a very specific unpack, but I think the key thing in the announcements is that sole traders are certainly connected to the announcement. The specific question about a working director who only draws directors, I guess, fees, if you like, I don't know the answer. And that will be something we'll have to unpack in the detail.
Yeah, so my thing is that people who are self-employed or if taking drawings, things like that, they'll need to provide a monthly update to the ATO to declare their continued eligibility. What that might entail, though, at this stage, we're not quite sure.
Great, but I think the good thing here is that we can put people's mind at ease that because our members have various structures and there was nervousness around, well, if I'm an owner, would I get it? Or if I've got employees, do I still get it as an owner? And I think the good news is that the answer is yes, and those finer details of how that looks is still to be unpacked.
Correct.
A question here around staff earning annual leave, long service leave and sick leave on this payment. Can you add any comments to that?
Well, from my perspective, the employees, if you've stood down someone, then you would continue to accrue all of those things regardless of this, because that's the idea of having been stood down, is that there's no work for you because the business has moved into hibernation. We've stood you down, which means we don't pay you a salary, but your entitlement continues because you're connected. And as soon as we're in a position to, we bring you back and you've had the protections of those entitlements. Now, where someone has been terminated and their entitlements therefore ceased from that point, you would obviously, on the basis that you've re-employed them, reinitiate the accrual process of the leave entitlements. Now, I haven't yet seen, Courtney, and maybe you have through your dealings so far, it's a tremendous question. If I've got a person who is only earning the 1,500 and he or she has got nothing to do because my shop is shut, do I accrue annual leave on the 1,500 and or long service leave if they're in that position or not? I don't know the answer to that question.
It's a great question. It's one that actually just came through earlier today from one of our members. So we've put out the feelers to try and get some more clarification around leave accrual on that. So we might loop back with members once we've got a bit more of a concrete answer on that, I think.
Great.
Yeah.
I'll just look through a couple of other questions here. So I've got a couple of members asking about maternity leave. And we've got a lot of questions popping in, so I've just got to find that question where it was.
I think, Charles, I can just say, I think on those minutiae leave questions, we don't know the answer. That detail hasn't been. I've got myself questions around people who are on workers' comp. I've got questions about people who are on maternity leave. I've got questions on people that are currently on annual leave because they have booked it and have gone. I think the leave entitlement and the application of where that all sits, we just don't have that level of detail yet. All those questions are being fed back through the Australian Chamber of Commerce, which we're a member of, and Courtney is heavily engaged in the discussions through processes with them. They were a principal party to the whole process, and I can assure you that's an economy-wide sort of question. So rather than, if I may, and not to cut that off, but all those sorts of minutiae, complex settings around leave, we will get the answers and we will get fact sheets out as soon as we can, so that everybody has a sense of, you know, whatever circumstance someone's in, whether they are or aren't, if it applies or doesn't apply, we'll unpack that as fast as we can.
Great. This is just, we have covered this off, but I'll just recap it. We have a question from someone saying that they've got a bookkeeper who they pay for 4 hours per week, but this bookkeeper also has another job where she's employed 16 hours per week. Is the 1,500 divided by the 2 employees, and how is this done? We did cover this off in the webinar to say that the employee will need to be registered to one employer only. You can't double dip per se. I don't know if you want to add anything to that.
No, they can't double. Go, Courtney, go.
Great point. So a person cannot, they cannot receive the JobKeeper payment from multiple employers. So they can only receive it from one. So they can continue working for multiple employers. If they have another job and they're earning from a second or a third employer, then that's okay. But they can only receive the JobKeeper payment from one employer.
Great, thanks, Courtney. With regards to demonstrating a 30% downturn, does that need to be shown to the ATO by a certain date?
Well, I'm happy to take that question. We don't know those details yet. At this stage, it's just a matter of opting into the scheme. I believe the ATO will then reach out to those employers that have opted in, and at a later stage they will provide more information around dates that they require particular information, and what information they're going to require.
Thanks, Courtney. Deb makes a comment here that wage tax has been scrapped until the 30th of June for businesses on full-time, part-time employees. Can you take back an employee on JobKeeper until the 30th of June only?
That's another technical question. I would suspect that the government's expectations would be that if you take someone on for JobKeeper, I believe that, I don't know this, but I would suggest to you that the expectation would be that if you make a commitment to put someone on JobKeeper, you would keep them on JobKeeper for as long as JobKeeper exists. Because I wouldn't think that they would want to have a scenario where we give it a test run, we all hate it, and then go, oh, that's enough of that, thanks, and then set the person off into the never, because I think they are looking for corporate Australia to effectively become their outsourced payroll. So I do suggest to you, if you're an employer on the line, once you've made a commitment, I think you need them in your own mind, unless of course your business becomes insolvent in the process, and I don't even want to contemplate what that would look like. But if you are going to make a commitment, I would suggest you should think about it being a commitment for the long haul. And if you don't feel you can make the commitment for the long haul, don't.
Thank you. So a couple of questions around having staff stood down, bringing them back, reduced hours, etc. So Tim here said, is it legitimate for businesses to bring back stood down staff on reduced hours to match the $1,500 payment?
Court?
Oh, well, I would expect yes. If they've agreed to come back in a reduced capacity, working to those earnings, and that you are passing on the full JobKeeper payment pre-tax to them, then I don't see why there would be an issue with that.
Great. And I think, Tracy, that also should answer your question as well.
So just to re-clarify that, I think that if a person's been stood down and you come to an arrangement that you're going to take them back on under JobKeeper, that you would be in a position to negotiate with them the arrangements around which that you would take them back on. So I know we've talked about the sit at home for free thing. If you're not comfortable with that, then don't take them on as a JobKeeper. If you feel that you want to take them on, but you want them to do something, even if it's a day a week, you want them to come and, I don't know, polish the floor, then if they agree to those terms, then you could proceed with whatever you've agreed. Just make sure it goes in writing. But and also I think the other really critical thing here is, and I do think this is going to become a particularly threshold problem, is that this is your decision as the employer. You can't be forced to do this. This is something that you have as an option, because at the end of the day, you are still in charge of the business, and you're the one that knows how much money is in the bank, and you're the one that knows whether or not you can afford to do this. So you shouldn't feel any pressure at all from anyone to take someone back into JobKeep if you can't afford to do it. And so I think in terms of the reduced hours piece, if you looked at 1,500 over a fortnight and you compared that to what they used to earn, you would come to an arrangement that you would both be happy with for how that would represent in the number of hours that you would have from an expectation point of view that they would work. Now, having said that, you would have to provide them with the tools to be able to perform those duties for you as per agreed. And that's, of course, further where it can get a bit complicated, because if that employee isn't equipped to be a remote worker, it's not fair to expect them to be able to do that. You would have to come to an arrangement, meaning if they said, well, I'm happy to use my laptop and I can get access to the GDS because that's okay and no problem, but I want you to help support me by paying part of my internet bill at home. All those conversations are likely to happen. They're all in the hands of the employer to decide what the arrangements are to proceed with going forward. There really isn't a textbook for that one. We'll give some thought to, from some of the questions that I've certainly received, about some variables, and we'll give perhaps some thinking around the sort of concepts you could consider, but all of it will be general in terms of the advice we give. Nothing would be able to be relied upon, because it really does at the end of the day come down to the individual employer to decide what they want to do and how they want to proceed with it.
Great. And I think this then answers another question, that if an employee was paid $3,000, but the business is obviously going down, and so therefore the requirements to work is reduced, you would need to talk to that. Well, you could communicate with that employee and say, I don't have work for you to be paid the $3,000 a fortnight, but I can give you reduced hours worth of $1,500, and you'd need to negotiate with them, I guess, a new arrangement during this period.
I think that's right. I think that's certainly a way to look at it, that you could negotiate and say to them, look, this way I can put you on the JobKeeper. We can stay friends and you can stay connected to us as a business, and we've agreed how that would look, and we move on. And if they say, well, that's not good enough, I don't accept, you say, well, I'm really sorry, the arrangements are such that the business is going into hibernation mode, and you'll have to go and seek support from Centrelink. And look, I know that's a really hard thing to say to people. I completely understand and get, particularly in the travel space, because everybody on this call is personally connected to your own people, and this stuff's not easy. It's emotional, and there's tears, and even in our own little world in AFTA, we've been through our own highs and lows in tears in dealing with our own people, just amongst the 10 of us. So I can imagine how it works out in the industry per se. But these things, you've got to agree to agree, and if you can't agree, then you've got to go the path you were going.
Great, and I think this will be our last question. Just a clarification, please, Courtney, for Tom, who says that he's got staff that have been stood down but still checking emails. So say they're doing 5 hours work a week, paying $150 a week. Now that they're eligible for JobKeeper and he can pay them that amount, is he still only required to pay the super on the $150 per week?
That's a great question. Yes, he's only required to pay superannuation on that amount that he was previously paying. However, they would be entitled to receive the full $1,500 before tax per fortnight now. So they would essentially receive a pay increase. However, your superannuation obligations would not change.
Fantastic. Well, it certainly sounds like an amazing solution to keep employers and employees connected. We'll leave it there because it is just a few moments to 2 o'clock. This webinar, again, has been recorded. In a couple of hours, it will be on the AFTA website. Use the quick link on the homepage to locate the webinar recording page. The slides will also be up there so that you can revisit. And as Jason said earlier, I do encourage you to go back over the content because the examples were excellent and really practical and no doubt helpful. So thanks for all the positive comments in. I'm glad it was a really useful webinar.
Thanks, everybody.
Thank you.